Good morning, everyone. I hope that you're all joining. Welcome to this EPC policy dialogue. I'm Sophie Pornschlegel. I'm a senior policy analyst at the European Policy Center and also a project lead of Connecting Europe. So maybe what's important in this context for this EPC policy dialogue on the rule of law is that I'm a political scientist, but we do have also lawyers here today because it's important to have those both perspectives on rule of law. Maybe on Connecting Europe, that is hosting the event today. It's a joint initiative of the European Policy Center with Stiftung Mercator to connect civil society initiatives across Europe with EU decision makers. And both Democracy Reporting International and the ECFR are part of this network with projects such as Reconstitution that focuses on the rule of law, or Reshape with ECFR in Berlin on the EU's role in the world. So today's discussion, it's a 1-hour discussion we will have, is on the now infamous decision of the Polish Constitutional Court, which happened almost a month ago on the 7th of October. Case K321 for the lawyers amongst us, concluded that the Polish national constitution had primacy over EU law on particular articles of the Treaty on the European Union, especially Article 1, 2, and 19. So this ruling really calls into question the legal cornerstone of the EU, because without primacy of EU law, there is really no point of having a common legislative process. And the Polish Constitutional Court's Tribunal's decision really went much further than other national courts' decision. There's been a lot of comparisons with Karlsruhe, so the German Constitutional Court, but I'm sure we'll go back to that. But it's really the first time it goes that far. What is important as well is that this court decision has to be read in the broader context of escalating tensions on the rule of law. There's been a number of infringement procedures of the ECJ against Poland, especially when it comes to LGBTQI-free zones or the muzzle law, which is the disciplinary jumper for judges. On the political side of things, I think it's important to remember that 88% of Poland's population opposes leaving the EU. There's been protests, Poles going to the street in Warsaw in defense of EU membership after the controversial judgment. So we'll also look at this aspect. Since then, as the French would say, there's been a number of péripéties, so a lot of happenings. The Polish Prime Minister gave a speech in front of the European Parliament. There's been a European Council where the issue was discussed but didn't end up in the formal conclusions. The EP backed a resolution labeling the Polish Constitutional Tribunal as illegitimate. And lastly, there's been also the ECJ deciding to give a fine to Poland of 1 million a day on refusing to suspend the disciplinary body for judges. We'll also go, and that's maybe for later, on the compromise that von der Leyen proposed for the recovery fund to release the money to Poland. So as you see, there's a wealth of issues to discuss in this context. And to discuss all of this, I've got 3 wonderful speakers with me. First, Jakub, who is research coordinator at Democracy Reporting International. If you follow on Twitter, I highly recommend you do so, as it's really interesting that he manages to get a good idea of what's happening in a witty way. Here we have Piotr as well, who is head of the Warsaw office of the European Council on Foreign Relations, who will be giving us the political perspective. And last but not least, she joined, welcome, Gwendoline Delbos-Corfield, member of the European Parliament and rapporteur on the situation in Hungary, who will also give us an EU perspective from the European Parliament, who has been very active on the issue. So I've talked enough for 4 minutes to be exact. So I will now go on to Jakub. You're the legal expert, and I'm sure not everyone in the participants are legal experts, but maybe if you could give us a take of what actually happened. I know you followed the discussions during, the judgment. So maybe can you give us a take of what actually happened on the 7th of October and what does it mean?
Thank you very much, Sophie. Good morning, everyone, and thanks to EPC for invitation to this discussion on what happened in Poland on the 7th of October and what are the legal and political consequences of that. Now, I will maybe start with providing you a little bit of a background and then briefly describe what actually happened and what are the consequences, the legal consequences that we are seeing in Poland. Now, as you probably most of you know, there was a continued rule of law crisis in Poland with the current government established by the ruling party PiS, Prawo i Sprawiedliwość, continuing to implement changes to Polish judiciary, which are being described by the government by reforms, but are seen by most experts, me included, as a phenomenon of the rule of law, backsliding, an erosion of checks and balances, an erosion of legal values that diminishes the oversight, in particular judicial oversight over what the government and the parliament are doing, and leads to a capture of various courts in Poland. And particular story of the judgment of the Polish Constitutional Tribunal begins with the changes to the Polish judiciary and the European Union's reaction to it. Belatedly and initially not strongly enough, the European Union's institutions have started reacting to what's been happening in Poland. One particular angle of, perhaps the most important angle of this reaction, are judgments of the Court of Justice of the European Union regarding the Polish judiciary. The Court of Justice has been increasingly speaking about various elements of changes to the Polish judiciary introduced over the last 6 years, and has found increasingly those changes to be incompatible with EU law. And in Poland, the judges, the ordinary rank and file judges, have started implementing those judgments of Court of Justice of the European Union. For example, by saying that the colleagues who have been appointed following those changes and the colleagues who have been appointed possibly under political motivation are not to be considered independent judges, leading to an escalation of this Polish rule of law crisis. And in response to that, the Polish Prime Minister, Mateusz Morawiecki, has lodged a case with Polish Constitutional Tribunal, ostensibly asking the tribunal to review whether the Treaty on the European Union is compatible with Polish constitution. And before I start talking about the content of the judgment, there has to be two things which I need to preface it with. First of all, the Polish Constitutional Tribunal is not a fully independent body. It is in many ways subservient to the government and the ruling party, and its pattern of behaviors in the last couple of years indicates that there is communication and coordination between the leadership of the tribunal and the Polish government. We've seen this in many cases. We've seen this in the abortion case last year. We've seen this in the story of the case on the length of the term of the ombudsman. There were behaviors from the court, from the tribunal, that could not be explained in any other ways than that they are coordinating with the ruling party. That's one thing. The second thing, the Constitutional Tribunal in this particular case has heard this case with unlawfully appointed judges on the panel. The European Court of Human Rights has found in its Xerof law ruling that one of the judges of Polish Constitutional Tribunal, Mr. Muszyński, the vice president of the tribunal, by the way, has been appointed unlawfully in violation of Polish law. And a very similar situation is shared by two other judges of the court. So we have a court that's not fully independent and that has been in this particular case composed with participation of unlawfully appointed persons. Now let's move on to what happened actually on the 7th October. And I think it's important to look at that event on kind of three levels. On the first level is the overt kind of legal level, where the Prime Minister of Poland asked the Constitutional Tribunal to verify whether the Treaty on the European Union, in particular its Article 19, which speaks about judiciary and which is the basis for the Court of Justice of the European Union to assess independence of domestic judiciaries in EU member states, whether that article is compatible with Polish constitution. And the Polish Constitutional Tribunal found that that is not the case, that the Treaty on the European Union is incompatible with the Polish constitution. That is kind of the first level. The second level of the story, however, is what was the actual legal issue at hand, because it was not about the clash between the Polish constitution and about the treaties, or at least this is how I see it. What it was in fact about was a clash between the Polish laws that enacted those changes to the judiciary, which enacted various elements of a new system of disciplinary measure against judges and various ways for harassing, intimidating, and going after judges who are critical of the government or who attempt to implement the judgments of the Court of Justice of the European Union, a clash between those laws and the case law of the Court of Justice of the European Union, which has been increasingly saying that there are issues with independence of judiciary in Poland, that various elements of those changes that Poland is implementing are violating EU law. And this was the real disconnect and the real clash. In legal terms, it has been kind of elevated by the Prime Minister and the Constitutional Tribunal to appear as a clash between the treaties and the Polish constitution. And in many ways, legally, this kind of has been a mock argument. And here I share the opinion of the dissenting judge of the Polish Constitutional Tribunal, Judge Pszczółkowski, who said that this is a mock argument, that the real argument lies elsewhere, and that the case presented by the Prime Minister and the decision put forward by the Constitutional Tribunal are actually a cover for the real issue. The real issue is that the Court of Justice of the European Union is increasingly speaking on about what's happening in Poland, and the Polish government is trying to discard it and is trying to act against it. And here we go to the third level, the political level, which I'm probably least qualified to talk about being a lawyer. However, it bears mentioning that I see it, the case, as an attempt by the Polish government to provide itself with legal cover for continued ignoring the Court of Justice of the European Union. What we've noticed in Poland is that the government is always keen to have some kind of legal grounds for its activities. And I see the judgment of the Polish Constitutional Tribunal as an attempt to provide the government with exactly this kind of legal grounds, an excuse, a kind of a piece of paper that they can rely on while continuing to ignore the Court of Justice of the European Union. And those are the kind of three levels on which the situation happened. And a lot of lawyers have been going on about whether what Poland did is similar or different from what the German Constitutional Court did last year, on whether what happened last month was a next chapter in discussion on how the European Union is to be set up legally and politically, whether this is all a kind of an attempt for Poland to exit the European Union. I think this is none of that. What I think happened was actually something that can be best described as a political attack, a hit job against the Court of Justice of the European Union, carried out by the Polish Constitutional Tribunal on request from the Polish government. The political angle of this is manifestly clear, and frankly, there is very little legal substance inside of it once you pack it all apart. So I would mostly see this event as a political move, but a move with very important legal consequences, because now we're getting into what actually has been happening in Poland following the judgment. So first of all, what happened is that some of the Polish judges have begun acting against this decision, and they have started to ignore it and to continue to give primacy to EU law and to implement the judgments of the Court of Justice of the European Union, and to continue to examine the independence and integrity of their colleagues in line with what the Court of Justice said, and kind of ignoring the decision of the Polish Constitutional Tribunal. And we've already seen some of those judges being repressed for that. We've seen at least one person suspended temporarily from their work as a judge due to the fact that they've decided to follow the Court of Justice of the European Union and decided not to follow the Polish Constitutional Tribunal. And this is escalating. So what we are looking at is kind of a reaction from the Polish judges, but also a danger of a rift in the Polish judiciary, because I can perfectly imagine that some of the Polish judges will defy the Constitutional Tribunal and will decide to follow the Court of Justice of the European Union, but some will do exactly the other way around. For various reasons, some judges may be afraid of intimidation. They may be already under the chilling effect of disciplinary measures being taken against judges in Poland, and they might be afraid of losing their job or facing consequences that could lead them to a unfavorable situation. Also, we cannot rule out that some of the judges will decide to follow the Constitutional Tribunal out of perception that this might win them new friends in the government and the ruling party. So we are looking increasingly at the situation where this all can start to unravel in Poland. In the wider European context, yes?
I'll have to stop you there. I will come back to what you said. Thanks for giving us that really good overview of what happened legally. You already mentioned the political aspects, and that's why I'd like to bring in Piotr at this point. Jakub, you mentioned it's a political move with legal consequences. Piotr, we know that Polish citizens tend to be very pro-European. What exactly does and we mentioned, we also heard that the Constitutional Tribunal is not independent anymore and it really works closely with the executive together. Do you see it also like this? What does peace want to achieve with it, knowing that this really is an escalation and that citizens do not necessarily, or at least that's what you can see from the polls, do not necessarily share that very anti-European or Eurosceptic positioning?
Yeah, thank you very much, Sophie, and thank you for inviting me to this wonderful discussion. I will perhaps follow up on where Jakub left it and come back to this political issue in a second. But I would like to start with a point which seems to me particularly important in this European debate about the Polish case, because we started this panel also with the verdict of the Constitutional Court, which of course provoked a lot of controversies across Europe for good reasons, and Jakub explained that. But I think but that brings us to a very complex and very difficult discussion about the division of competencies between the national institutions and EU institutions. But I think what is really the heart of this disagreement, or the problem we have, actually it's not a disagreement, it's a fundamental crisis of the European Union, is a very simple question. And the question is, can we have a EU member state without independent judiciary? Because we should actually have started also this discussion with a very brief explanation how the Polish judiciary system works. And and of course, I don't want to go into details about that, but I think this is of fundamental importance to understand that we have a system of judiciary in Poland at the moment, which does not have systemic guarantees of judicial independence. So basically, to be an independent judge in Poland requires a lot of courage. Because you can be, as a judge, you can be punished for the verdicts you have issued. You can be, the Minister of Justice is basically in control of the whole disciplinary system of judges in Poland, can go after each and every judge personally in Poland, and can, for example, which happened even after the verdict of the Constitutional Court declaring the system for violating the EU rules, that the Minister of Justice personally suspended a judge in Poland because according to the Polish law, the so-called muzzle law, it has the right to do so. So without going into much detail, I would encourage you all to have a closer look at the system works, because it only then you basically can understand the magnitude of the crisis we are in. So basically, we have a EU member state without independent judiciary in formal sense. There are many independent judges in Poland, and this is, I think this is really important, because then the question is, okay, so what should we do about it? But I will leave this question for a second, and coming back to these political aspects of the judgment. The only reason the court of the Polish Constitutional Court issued this particular judgment was an attempt to prevent the implementation of already existing verdicts of the Court of Justice of the European Union. There are two important decisions the Court of Justice of the European Union has already issued. It happened in July. It's, as I said, in one full verdict declared the whole system of disciplinary proceedings for judges in Poland as violating the EU treaties. And in a second decision, by imposing an interim measure, the European Court suspended parts of the European law, which basically in open way threatened the judicial independence. And then, so we have, and these are two important, very important decisions of the Court of Justice of the European Union. And the aim of the Polish government is to prevent their implementation. And these are binding decisions. So now the question for the EU is, so how do we go about it? Can we allow a government to just ignore verdicts of the Court of Justice or not? And then the question, the political question is, of course, why is it all so important for the Polish government? And what is the political reasoning behind it? What is also the room of maneuver for the Polish government at the moment? And I think what is key is that this judicial reform is a centerpiece of the political project of Jarosław Kaczyński, the leader of the Law and Justice Party. Kaczyński already years ago defined or coined a term of impossibilism, basically pointing to the fact that independent liberal democratic institutions prevent the democratic majority from carrying out its political projects, and that those independent institutions need to be more restrained in their activities, because otherwise, the majoritarian democracy cannot work. And of course, the takeover, the political takeover of the Constitutional Court happened already 2015, just after the Law and Justice Party came to power. And I was by no accident, as Jakub mentioned, this court has been used many times to basically help the parliamentary majority and the government to introduce some laws or declare unwelcome provisions of the Polish law as unconstitutional, simply upon the request of the government or organizations close to the government. And then we have also the general courts, and here you also need to have a full control of the judiciary in order to have a full control of the state. And so this is a very important project of Kaczyński, and he's very much determined to push it through, because his kind of autocratic power grab will not be complete without this, without completing this indeed. And then we have also other actors in the Polish government, which, and to understand the Polish political landscape, is very important to mention them. And one of them is Minister of Justice, who is Mr. Ziobro, who is leader of a very small party, having, I think, at the moment 15 seats in the Polish parliament. But the parliamentary majority of the Kaczyński party is of the government is very much dependent on the support also of this party. And for Mr. Ziobro, this is a real pet project. So he is without. So he basically, to put it in a very simple words, he cannot accept any compromises when it comes to the judicial reform. He cannot withdraw from what he has already achieved, because otherwise he would compromise himself. And we have also Prime Minister Morawiecki, who is who's trying to play the role of a pro-European and compromise-oriented politician, but he's fully dependent on Jarosław Kaczyński, and also hostage to this very peculiar situation of the government, which is dependent on the fringe party being very much committed to judicial reforms. And just last sentence, the situation for the Law and Justice government politically is extremely difficult at the moment. The parliamentary majority is very, very slim. It's just 2 or 3 seats more than the required majority in the parliament. According to the opinion polls, the party's popularity dropped by 6 percentage points over the last weeks. It's now below 30%. It's still the strongest party in Poland, but it's below 30%, and there's no way the party would be able to win a parliamentary election if there was any in the coming weeks or months. And also the judicial reforms do not enjoy popularity in the Polish society. More than 50% of polls is of the opinion that it is the Polish government, which is, or to put it differently, this is the Court of Justice of the European Union who is right in this conflict. And more than 50% of Poles have also negative opinion about the state of the judiciary, basically saying that its functioning has worsened in the course of these reforms. So it's a very difficult situation politically for the government at the moment, and this political spat with the EU institutions is adding fuel to it.
Thanks, Piotr, and we'll come back to that because I think that's a really interesting point to see that Poles or citizens might not necessarily, have the same opinion as the current peace government. But welcome to Gwendoline Delbos-Corfield. Thanks for being here. You're a member of the European Parliament and you've been following what's been happening. I know or most of you will know that the European Parliament has been extremely active in the field with a number of resolutions to, one, for instance, put forward the rule of law conditionality mechanism in the EU budget, but also labeling the Polish Constitutional Tribunal as illegitimate. So we saw that the legal perspective, the political perspective within Poland, and now we're coming to the EU's response. We know it's a very sensitive situation. It's a difficult one. We saw that we do not necessarily have an independent judiciary anymore in an EU member state, which is not the smallest one either. So my question to you would be, what do you think should the EU do? And as EU, the different institutions, because we've seen many different responses from the European Commission, from the European Court of Justice, from the EP, and also from the European Council. So what do you think should be the strategy of the European Union looking at Poland?
Yes, hello, thank you. I will just start by stating the fact that I'm very ill, so I hope my voice will manage it, and I'm sorry if I look very bizarre.
Well, thanks for coming in that case.
Second, I just wanted to add that I'm the rapporteur of the Parliament on the situation on Hungary, which of course you cannot study without working on the situation on Poland, because not only the two situations are similar on a number of topics, but of course they are now two member states that are acting together in a number of cases, because they know that this is giving them leverage, and also of course just by the fact of breaching the rule of unanimity. I mean the need of unanimity, they can prevent a lot of things. So when you work on Hungary, you work on Poland, and vice versa. I just wanted to start by one specific point. I think it has been said by the two previous speakers, but I really want to insist that we are in European Union, and I think that Parliament has said this very clearly, some member states also, Commission, we are facing two different challenges and two different problems when you talk about Karlsruhe, for example, and a number of other topics where member states are questioning sometimes if there is supremacy of, or not that there's supremacy, but are questioning some things decided by the Court of European Justice, and just thinking, how do we adapt it in our country, in our member states? This is very different from what happened in Poland. And one of the big error would be indeed to interpret all as the same thing. There are more and more frictions. I use this, the French word frottement works very well. I am not sure in English it works very well, but there are more and more frictions between our national laws and European laws, and mostly, and not mostly, but specifically on these topics of judiciary cooperation and all of this. And we're having more and more questions, and it's very good, healthy, that we have more and more questions of judges in all member states going to the European Court of Justice saying, in this specific case, what should I apply and all this? Because of course, in this moment where we are harmonizing a bit more certain of our laws, at the moment where we are cooperating on a number of things, of course there are these things. And in fact, these rule of law breaches in Poland, in Hungary, are one of the questions that come back from the other judges. Judges today in Ireland, in Portugal, in a number of member states are sometimes asking, should we go full for judiciary cooperation as we are supposed to do? We're in two member states where independence of justice doesn't exist anymore. So in fact, this situation in Poland and Hungary is creating itself frictions. And this is very, very different to this very clear refusal of the Polish government to apply the supremacy of European law on fundamental things, which is not questioned by the other member states, and using for that this constitutional court, which is no more independent, which is no more a real constitutional court. It's a political court where the people have been appointed by the government itself. And this question was raised, it was said by the Prime Minister himself. It was a clear, organized and coordinated process to get this ruling, and nothing more than this ruling was expected. It wasn't supposed to be anything else than this ruling, and this was very political from the very beginning. And the state of the independence of justice in Poland is very, very bad, even worse than in Hungary, and indeed even more on these very high level, which are Supreme Court, constitutional courts, and all of this. This is the first thing. And why have we arrived here? Because indeed we've had no real political acts, not enough political acts for years now. Indeed, it has been said, the Polish government and the Hungarian government, even more, the Polish government in this is now copying the Hungarian government. They had made the trend. They try to always give very technical and very thorough judicial background to what they do. And they try to do it for their narrative inside and outside. Inside, in the countries, in the member states, they can say, you know, no, this is all legal, this is all normal, it's just European Union not understanding our legal system, our judicial system, and all of this. But it's also because outside it has allowed them to gain so much time. They have been on this judicial ground for 10 years in Hungary, and that has helped them to go on doing what they did with no political real answer, because the political, and this is a real weakness of the European Union, because the political structures like the Commission and the Council were very eager to leave it to the judicial system and let them deal with the system. And this, and because all of this is very political, and it's a political will to change what is rule of law, political will to change how you do democracy and all of this, it was a major error, I think, of the political structures to only answer on the legal and judicial ground. And this is a fight in which we have been in Hungary for 10 years. For a long time, Polish government was much more ideologic, which of course always triggered political answers, which was not good for them. So now they have understood that they should always go on the judicial ground. And of course, they are trying to turn around the narrative inside and outside again, saying that there's not one rule of law, there's not one way of independence of justice, there's not one democracy, because this is the way that they can try to make their system be accepted. And they have been challenging continuously, and continuously they have been challenging, avoiding to have huge political answers. So what should the European Union do? It's just politically answer. It has been doing it since 2 years in a bit more thorough way. There has been hearings. These hearings in Council by the other member states are something that Poland, like Hungary, do not like at all. They do not like to have to be under the pressure of the other member states. The other member states don't like it also, so they try to avoid it, but we have managed to get them do it. We hope to have others in Slovenia, and now we need to go to the next step of this Article 7 process, which is to get recommendation. But there's also a very easy way, which is, of course, the infringement procedures from the Commission. They have been doing it, but not in a systematic way, hesitating a lot. I mean, I always give this example that whenever in a member state you have a problem of competition, the Commission makes an infringement in the day. And the number of infringement procedures against all member states because of competition questions and the fact that this firm bought this firm and it wasn't done in the rules of competition and all this you have all the time. On rule of law aspect, we have to basically, you know, in Parliament push Commission time and time again. We, the activists on the ground, some experts, some legal politicians and political advisors and all this for them to act. So they have been not enough infringement procedures. And of course, now there is the question of the money. Hungary and Poland, what has been for a long time hesitation on the European Union point of view was, should we deprive the people of the money when it's the government that are acting bad? The question is, will the money go to them anyway? In Hungary, the level of corruption is so bad that you can really, really wonder. So I think that there's no more question to be questioned in Hungary. I think we should be very much more strict on giving money in Hungary and having very strict conditions for the recovery plan, like for the other money, that the other subsidies that comes from European Union. On the Polish side, the corruption doesn't seem to be as high. This is not the statements that we have from OLAF and other structures that monitor corruption, but this question of independence of justice is, of course, huge, because should we be giving money when we will, if there's a problem, we will not have an independent justice to defend the European money? This is a real question that the member states have to ask themselves. And this is also something that should really make European Union, Council and Commission hesitate when they do allocate money to Poland. Just to finish, yes. I think this is a huge threat, indeed, because Poland is playing on this misinterpretation that this could be a way to really challenge European supremacy law. And it creates an uncertainty, even if we are a lot of people saying this, you shouldn't confuse the two debate. It has created this uncertainty. So this is a real crisis, but also, and I want to really insist on what has been said before, the fact that this government and the one in Hungary for years have been challenging rule of law in a very blatant way against their own population, because you've said it, population show that they believe in independence of justice, they believe in pluralism of media and all this against the government, and there was no reaction. It is really giving the impression that in the European Union, you cannot stand what is our founding grounds.
Mm-hmm. Thank you so much for giving that view. And I think it was very interesting that you're saying that we need more political action, knowing that, for instance, the European Council did not put Poland in the formal conclusions and decided they discussed the issue, but really do not want to, said that the Commission was the guardian of the treaties. Looking at the different possibilities the EU has, we know that Article 7 has stalled for years now. We know we have infringement procedures, and I think the other really big pressure instrument is, of course, funds. The rule of law conditionality, where the Commission also, the European Parliament decided to sue the Commission, but also the Next Generation EU funds. And I have a question, which I would first bring to Piotr on the Next Generation EU recovery funds, because we know that we have 36 billions that are waiting to be sent to Poland. And von der Leyen a few days ago proposed a compromise saying that you now have to take back the measures that have been taken on the judiciary, on the disciplinary chambers. Do you think, Piotr, that there will be some kind of political agreement that this can be solved with a compromise?
Yeah, thank you, Sophie. And let me answer that by also referring to what has been just said by Gwendoline and some broader issues, also comparing Poland and Hungary. And I will do it in very brief. I think, we need to understand that there is one profound difference between the Polish and Hungarian case at the moment. And the difference is that we have a binding verdict on the Polish judiciary regarding in the Polish case, which we do not have in the Hungarian. I think this is extremely important, because if we discuss what kind of steps the EU institutions should take, this should be our main point of reference, because I think the infringement procedures and the role of the Commission and the Court of Justice is extremely important. This is the most efficient mechanism of protection of the rule of law in the European Union so far. And it will be extremely efficient if there is a full backing for this particular mechanism from the EU member states also at this very moment, and if the European Commission remains firm in the defense of this mechanism. And I think this is what is at stake, the authority of the Court of Justice and the authority of the Commission. And I think, so I wouldn't say, and probably there is no major disagreement between me and Gwendoline, but I wouldn't say that this political path, the political track of the Article 7 procedure is now the one we should explore. What we need to make sure is that we basically go on the path which has been started with the infringement procedures initiated by the Commission, and which had its peak basically with the decisions of the Court of Justice I referred to before in July. So what really matters, and here I come also to the Recovery Fund and von der Leyen's ideas, what really matters is that 2 verdicts of the Court of Justice of the European Union from July are actually implemented. So it is not so important what happens to the Polish verdict of the Constitutional Tribunal, if there is an infringement against it or not. What really matters is if the Polish government implements the verdicts of the ECJ from July or not. Because if it does, the situation in Poland would improve massively. And secondly, if it doesn't, the authority of the Court of Justice would be demolished. If we allow the EU member state to ignore a binding verdict. And what I mean by that, so what my suggestion is that we should, what the European Parliament also and the European Commission should focus on is not, and I'm sorry to say that here, where we're discussing also the role of the European Parliament, the role of European Parliament is not to insist that the Commission triggers the rule of law mechanism. This is not the priority. The priority should be that the Commission does whatever it takes to make sure that the verdicts are implemented, which are already there. And you can do it in twofold way. The first thing is that the Polish government has not implemented any part of this. It did not even start discussing the implementation of those verdicts, which means that the Commission can request a fine from the Court of Justice European Union for the non-implementation of the verdict, because the 1 million fine which has been already imposed by the Polish government on the Polish government by the ECJ, it is a fine for the non-implementation of an interim measure from July, not for the non-implementation of the full verdict, which is still pending. So this is one way, the second infringement. And the second is what Sophie alluded to, that we have the recovery fund money and the Polish National Recovery Plan waiting for acceptance by the European Commission. What von der Leyen suggested last week is a kind of a, maybe not a compromise, but a solution, which is pointing in the right direction. So what she basically says, the Polish government has to commit to the full implementation of the July verdict on the disciplinary courts or disciplinary system for judges. But of course, the problem is that I don't really honestly believe that you can trust the Polish government to fulfill its commitments. So if we release the money, just referring to some or on the basis of some general commitments to the reform of the disciplinary system or to some other changes, we may not solve the problem at all. But of course, if it has to be about commitments and not actual implementation before the money is released, these commitments should be defined in an extremely precise way. Because what we see today is that there's already a new judiciary reform underway in Poland, which is pretending to address the problems identified by the ECJ, but which actually, in the end, will, as we learned yesterday, there was an announcement or a leakage of draft proposal that will basically kill the Supreme Court altogether, and if implemented, and it will put an end to the independent judiciary in Poland at all. Yeah. So I think, so we need to really make sure that we avoid a fudge when it comes to those committees.
Thanks, Piotr. Jakub, before I come to you, because we already have a few questions coming in, I'd like to give the opportunity to Gwendoline to respond, especially because there's also a question on that about the case that has been filed against the European Commission by the resolution that's been taken on the inaction of the Commission, and how do you see it play out? Do you think that this is the right way of going forward? I know I've heard a lot of people who said that, this is not the way of going to having some kind of interinstitutional competition or contests on who takes what decision. How do you see it? And do you think, how can it play out to say that the Commission should act more on that issue?
No, yeah, I think the Parliament is right to act on this, because it has to act where it can. And for the moment, I must say that I think members of Parliament are the ones that are the most courageous on this. And I'm not talking about me. I mean, I come from France. I'm taking no courage at all. It's hard work, but it's not courage. It is for some of my colleagues coming from these member states. And it was already when they voted Article 7, sometimes when they were even in the same group as Fidesz for Hungary, for example. So I think that we need to do it because this is our role. I do agree that all tools are complementary. That's what I always say. I hate the fact that at one moment, some of my colleagues in Parliament were all about rule of law conditionality mechanism and only that. And that would resolve everything. And we should stop Article 7. And I hate when people say Article 7 is completely weak. Well, it hasn't been used. So of course it's not working. And then I hate it when people say it should only be the Commission doing everything, because no, it's not only the Commission, but the Commission has its part. All the tools have to be used together, and the governments need to have also political answers and response, not only a judicial one, because they need to understand that when you belong to European Union, you have to accept the fact that pluralism of media, independence of justice, and a certain number of democratic safeguards are part of the pack, and you cannot choose in European Union not to take these packs. And we have been letting these governments think that that was possible. And that's what they are trying to do as a narrative in their own country. They are saying, it's just that we do not have the same definition of rule of law. Well, independence of justice is not one or another definition of rule of law. It is the definition of rule of law. So I really think that the lack of political answer was a big weakness at our moment, and we need it next to the judiciary one, of course. And I think that the Commission is always a difficult structure to put in action. As you said, Council is often turning to it saying, you are the guardian of the treaty, but we don't see them act as quickly as we want. Also because there's a problem in the college, we know that also. They act as a college, and that is not easy for them. So I think that it's good every time the Parliament push them. We have shown that it is every time that the Parliament has pushed that things have happened. It has been the case for 5 years now. So it's when the Parliament asks for something. I mean, Article 7 process would not even have been triggered against Poland if before Parliament had not been triggering it against Hungary, the government of Hungary, which the Parliament had been asking the Commission to do for years, or the Council, and nobody was doing. And if the Parliament went for it, it was only because they had been waiting. So I think that we are very much in our role when we do it. It's not breaching the interinstitutional discussion, it's pushing our colleagues when we find that they're not making exactly the job that they should be doing. And don't worry, Council and Commission come back to Parliament when they think that we're not doing our job. So all of this is very fair.
Thanks for the clarification. Jakub, I'd like to come back to you. If you can maybe don't hesitate to comment on especially the solution that von der Leyen proposed, but also there's been a question, and because it's been really one of the biggest discussion about how the Karlsruhe judgment eventually served the purpose of the Polish government and whether you can see some kind of domino effects from either Karlsruhe or now the Polish Constitutional Tribunal.
Thank you. So I was one of the many critics of last year's decision by the German Constitutional Court, which I thought was very unfortunate for several reasons. However, I will allow myself to throw a lifeline to Karlsruhe Court here and to state that we have some fundamental differences between the decision of the German Constitutional Court and the Polish Constitutional Tribunal. First of all, like I said earlier, the Polish Constitutional Tribunal is not independent and has passed out this decision in a composition that includes unlawfully appointed judges. The German Constitutional Court is one of the global benchmarks of judicial independence and is famous for its assertiveness against the German executive and legislative branches of power. It is also fully properly composed, so there are substantial qualitative differences between the both courts. But even if we look into the decisions themselves, there are substantial differences. The PSPP judgment of the German Constitutional Court spoke about a very narrow slice of EU law and policy. It spoke about the capacity of the Court of Justice of the European Union to review the bond buying scheme of the European Central Bank. Now that's quite important, especially for economists out there, but it is a really narrow scope of EU law, while what happened in Poland last month was about primacy of EU law, at least overtly, a fundamental principle of EU law. That's a huge difference and makes it very difficult to compare those two judgments. And third thing is that the German judgment came about from a individual constitutional complaint, while the Polish judgment came about from an application from the Prime Minister, the government of the country, an EU member state. And the most important thing is that I believe that everybody involved in the PSPP judgment of the German Constitutional Court was deeply mistaken, but acting in good faith of sorts, and were probably envisioning that they are contributing to a development of EU law and the division of competences and powers between the member states and EU institutions. While in case of Poland, all we can see is bad faith from everyone involved. Pretty much everyone in the courtroom of the Polish Constitutional Tribunal, the representatives of the applicant, the Prime Minister, the judges of the tribunal, but also the other participants of the proceedings, all of them, apart from the Ombudsman's office, who were the only ones in any way arguing in favor of EU law and in favor of primacy of EU law. Everyone there was pretty much out there to go after the Court of Justice of the European Union and to provide the Polish government with legal grounds to ignore the Court of Justice. Those are all fundamental differences, which make it, at least for me, impossible to consider those as similar. And also, it means that those circumstances would take for those circumstances to arise in another EU member state for a similar situation to develop. We would need a malicious government acting at bad faith and a captured constitutional court for this to happen again, which is not I'm saying that is impossible. I'm looking a little bit worried at Hungary as I speak, but very difficult to imagine in most EU member states. I believe that the independence and integrity and quality of constitutional courts in Czech Republic, Italy, other countries would serve as a barrier, even in case the government themselves in that country would have an idea similar to the Polish government. So I'm a little bit optimistic and safe about most of EU member states. And now just quickly taking the opportunity to speak more about solutions. I think this is very important, looking at both what von der Leyen proposes and also what are the signals coming from the Polish government that we will abolish the disciplinary chamber of the Supreme Court, that we're going to reform the Supreme Court. It's very important to look at the July decisions of the Court of Justice, which Piotr mentioned. They don't speak just about liquidating the disciplinary chamber. They speak about the need to revamp and dismantle most of the system of disciplinary action against judges. It's not just about the fact that there is a dedicated chamber at the Supreme Court. It's also about the muzzle law. It's also about the ability to go after judges over the content of their decisions. It's about being able to go after judges whenever they speak about independence of their colleagues. It's a whole system. And the Court of Justice of the European Union says this system must be dismantled because as long as it persists, Article 19 and the independence of judiciary in Poland are in peril. And merely throwing out some kind of very formal solution that will not touch upon the real core of the issue, it's important that if Poland will propose something like this, the Commission will not buy this kind of smokescreen and will not allow a situation where they will sign off on the unlocking of the recovery fund or consider an implementation of the July decisions, while in fact the issues will persist. And this is very important, and as Piotr mentioned, the challenge here is that for the Polish government, the ability to go after judges and the ability to inflict this chilling effect, which will scare the Polish judiciary away from reviewing the actions of the government and performing their role of oversight. This is what the Polish government is really about and what they are going after. And this is important not to let them cover it with some kind of a very formal excuse and sign off on everything, despite the fact that the real issue will persist.
Thanks, Jakub. We've got only 5 minutes left. It's going really quickly because there's so much to discuss. There's one thing we didn't discuss yet, and I'd like to mention it because it's been very much in the media, and lots of people talked about the kind of legal polexit and looking to the future. I mean, it's a very populist term in a sense, you know, looking sensationalist, which makes headlines, but how would you consider this a possibility? Do you see really escalating tensions leading to Poland at least leaving the kind of legal union that we have? Or what kind of future would you see? And I'll start with Piotr because you're the political expert on that one.
You know, we could discuss the legal polexit at length, but I think it's already happening. I mean, we have already cases where some decisions of the Polish judges or Polish courts are not respected by other courts in Europe. We have decisions of European courts that, for example, denying extradition of Polish citizens to Poland in the realm of European arrest warrant. So I think that it's already happening, and it cannot be. I'm sure this cannot be prevented. This legal chaos affecting also not just the Polish judiciary, but also the European legal order. It cannot be stopped without. As Jakub mentioned, the full implementation of those verdicts. I think here the stakes are extremely high for both Poland's place in the EU, Poland's democracy in general, because I think we need to be very clear about that this is, you know, a key fight, a key battle when it comes to the future of the democratic order in Poland. It's not just about technicalities of the judiciary system. It's about the future of democracy in the middle of Europe, and I think that should be pretty clear that this is what it's taken. At stake is also, as I said, the authority of the EU institutions responsible for protecting the democratic rule-based order in the European Union. And I think so. This is because this is, I think, my last word. I just wanted to underline this because sometimes we deal with the nitty-gritties of you know, judicial matters which are not very comprehensible for the people, but in fact the thing is extremely simple, that we have a situation where we can have a autocracy in the middle of the European Union, and everybody's looking on, and I think we need to act before it's too late.
Thanks, Piotr. And as a concluding round, and I know there's been lots of questions, unfortunately we won't have time to answer all of them, but I'd like to maybe end this round on a more positive note, or looking forward also. So if each one of you could maybe tell me what their concrete wish would be as a next step in the current situation we're in, what do you think the EU should really do as a next step that you think would be really helpful? And maybe Gwendoline, because you're part of the European Parliament, you start off.
Yeah, I really want the three institutions, Parliament, Commission and Council, to be very harsh with the Polish government, because The hope is in the population. You've told it, the polls show it, but also the fact that they have demonstrated, and that's not the first time that they demonstrate. They have been demonstrating for years now on a number of topics when they have seen some threats to their liberties, so to the freedom and also the things. We have a huge battle from the judges themselves. I mean, the judges in Poland are very courageous. They have asked for help now for years. They are coming to Brussels and Strasbourg to say their story. They have been challenging the national decisions and the national laws. So there's a huge potential in the population. And as it has been said before, this government is not in its best state. There is a possibility of a change of government, and there's a possibility in Poland to come back to normal and to not have this autocracy Piotr was talking about. I am much more concerned about Hungary, where the captation of the state is huge. In Poland, it is not as much the case, and I think there's still hope in Poland. In Hungary, I'm much more worried.
Thanks, Gwendoline. Jakub, your concrete wish if you were in the machine room of the EU?
I would actually take one step outside of the machinery of the EU, because we haven't spoke about other EU member states. And I would be very happy if the other EU member states, who are increasingly more and more interested in what's happening with the rule of law in Poland and Hungary, would step out of just the rhetoric and being the friends of the rule of law and talking about this and move towards concrete action, for example, by launching interstate cases before the Court of Justice of the European Union against Poland and Hungary over the damage to the rule of law. This would not only relieve some of the burden of the Commission, but it also show that people in Portugal, Ireland, Netherlands, and the governments are so heavily concerned with what's happening with the country there that they are ready to take it to the court and kind of follow the example of Czech Republic in their action in the Turów coal mine case, which is of course a completely different area of policy, but still shows that at some point the damage is so big that you can discard the political kind of care and worry about the state of bilateral relations and move forward to defend the EU values. That's something what I would be super happy to see in the coming weeks and months.
Thanks. And Piotr, very quickly, your last word.
Yeah, I think I've already indicated what would be my wish, and my wish is extremely simple, because what I would wish is that the EU institutions, especially Commission, but also the Council and the Parliament, basically implement the EU law and fully, and request the same from the EU member states, which in concrete terms means that the whole focus of the political energy in the coming weeks should be on the full implementation of the two verdicts the Court of Justice have already issued and which are binding for the Polish government. And the Commission has tools to demand and to enforce the implementation. And in these tools are the second infringement before the Court of Justice of the European Union for the non-implementation. And the second is the linking of the release of the recovery fund money to the full implementation of both verdicts.
Thanks, Piotr. We are 3 minutes late, which is I hope is okay still to start your day after this 1 hour of rule of law policy dialogue. I'd like to thank you all for listening in, and especially to the speakers for giving their insights. It's not an easy issue. There's a lot happening at the moment, and we will continue at the EPC and of course at Democracy Reporting International, at the ECFR, and of course in the European Parliament to follow the issue, I'm sure. Yeah, that's it for today, and thanks again for participating. See you.